is if the results that have not come are officially cancelled. That was not the case. No, they were not. They were not cancelled. The returning officer simply proceeded to declare the winner without receiving all results from the constituency, my lord, as is the command of section. Let me begin with the law, my lord. Section 72, the PEA, which the lordships in Mzanzia were interpreting. If you are interpreting in the former section 58, now it is 72, 1. Now it is 72, 1. It provides, my lord, that 72, 1 says after all the envelopes containing the declaration of results forms have been received, the returning officer shall, in the presence of the candidates or their agents, or such of them as wish to be present, open the envelopes and add the number of votes cast for each candidate. You do not declare a winning candidate without all the envelopes. Now, my lord, in Bamzanisa, they said, of course, you can begin tallying. Okay, if there is, and that's also provided for in the law. You can begin tallying, but declaration, you do not do so until you have received all envelopes. I was saying that the exception, my lord, they created is of the decision, my lord. I'm at page 751 now. 751. I'll get for you the page of the exception, my lord.
What makes the results provisional?
If they're not complete, my lord, that's all. If a constituency has 197 polling stations and you have results of 170 polling stations, they are provisional.
It's not the case where they say 10,000 votes, and after more I'm carrying the votes maybe 12,000. So in that case, we say yes, the other 10,000. Now more results are carrying, and total votes cast at 12,000.
Even that, my lord.
That's why you say
even that, my lord.
10,000, but now more votes are counted. Now total votes cast is 12,000. But in this case, it never changed.
Even that, my lord, which you have said, happened and is unlawful. First of all, what you have just said happened in this case and is unlawful. Okay? At the time of declaration, the results were different. At the time of gazette, the results were different. In Muzanzia, the court of appeal has said that is unlawful for the returning officer to do, first and foremost. This decision has told you once you issue a return form for transmission of results, you can't touch it.
So you were saying they were different.
So
declaration, what is covered in your evidence?
My lord, I only put the final declaration where that which you are saying.
You don't have that in your evidence.
No, my lord. The previous results, but that was not my point. The point was that because you do not have all 197 envelopes, BR forms, the only implication is that what you have declared a provisional results. I was, my lord, taking you to the exception that you had asked me. That same page, 751, where I am. Just below the second highlighted part, there, my lord, they are saying, unless they are cancelled. And the second respondent did not tell us that they cancelled. They did not. And cancelling, my lord, is not by indication. We appreciate, my lord, after the second highlighted part, down there, after the second highlighted part, down there, it says, we appreciate that there are cases where certain results may be missing or cancelled, and the available results are used to declare a winner. None of those applies to this case. They were not cancelled, they were not missed. So that's non-compliance, my lord. So the law commands the returning officer to only. They were not missed. No, my lord, my lord, you cannot miss something that doesn't exist. This was a question of non-existence of that, not missing results. Missing results is this: that results have been declared, like in Nyakechu, Saropen. Results have been declared, the other forms have been filled along the way, the transmission. Then they disappear. The Court of Appeal has dealt with missing results. These were not missing because they were not there in the first place. So I'm saying this therefore does not apply to our case. And cancellation, my lord, is of course, you can't do it by word of mouth. Okay, there is a procedure, my lord, if you want to cancel results. And the EC has not said, my lord, that they cancelled. Not at all.
So if they were not there, what is the expectation?
What? Then the question, my lord, would be, what does the law tell them to do? I've just referred you to the law. Postpone. Yes. The voting. Get to the next. And how? Because you see, my lord, after the election is held, the law commands the EC to declare a result in 48 hours. They still had time. Yes, so they could have held the election again in those 14 polling stations. The next day, they will give them that option, and they did take it. Now, my lord, which brings me to the second limb of this issue, which is the issue of substantiality. Now that, my lord, I have told you and I've given you authority and evidence that there was non-compliance with the provisions of the law, the next issue is whether that non-compliance affected the result of the election in the substantial manner. My lord, I will begin with the decision of Elizabeth versus 7. We all know it's a very huge decision, but it's the excerpt I'm referring to is reproduced in the case of Bantali Isatali Gola versus East. Basically of 201. Bantali, where that excerpt is quoted, is at page 818. But the case starts at 793. Bantalibu Isa Kaligola versus Isi and Oronedem, 2021. The excerpt I'm referring to of Giza BCJ is captured there. Page 818. 818 of the second point. My lord, is 818. That's where the holding is, but the case starts at 793. The case of Bantalibu Isa Kaligola versus Isi and Oronedem. Now, my lord, permit me, my lord, to refer to that excerpt. I will not read the whole of it, but towards the end, His Lordship was trying to explain what substantial effect means. He says, that means that to succeed, the petitioner does not have proof that the declared candidate have lost. It is sufficient to prove that the winning majority would have been lost. Such reduction, however, would have to be as to put the victory. What does that mean, then, my Lord? It means that in this petition, we don't have to prove, my Lord, that the winner would have lost or that the loser would have won. It is enough in this petition, my Lord, if we prove, and we have, that the number of people whose electoral choice was not ascertained by the Electoral Commission is greater than the margin between the two candidates, between the winner and the first runner-up. That is what we have to prove. Okay. I will have established substantial effect, my Lord, if I prove that because of this number of people whose choice we don't know, because nobody knows how they voted, is greater than the margin. My Lord, the margin between the first respondent and the petitioner is 8,881 votes. Those whose choice we do not know, but we are clear voted at the election, is 16,640 votes. They are almost double the margin. They are almost double the margin. 16,640. 640. But the margin.
You have the big tip there. Can you check the total? You can reduce this 16,640 from the 16,640.
Yes, I didn't get your question, my Lord.
16,640.
Yes.
The number of total voters is
14 points. Yes, ma'am.
I want you all people there to check the total number by checking
the tally sheet.
No,
So subtracting this from
by
the
taking by looking at the attach the rows, the voters' rows.
yes, my Lord.
The voters' rows.
Yes, my Lord.
You can then check us. Also add up all the voting stations.
Okay, they will do that, my Lord, as we go. But you can also get
Whether that is the figure.
okay, my Lord. But you can also get it, my Lord, from the tally sheet. The tally sheet gives you the number of registered voters per polling station and those who voted. If you look at the tally, it would be easier, my Lord. But even that they can do from here. But you can easily get it from the tally
Do
sheet.
that
Okay. I'm obliged, man. Now, what I was saying, my Lord, is that the margin between the winner and the first runner-up with the petitioner is half of that number, nearly half of that number, at 8,881 votes. When she was here in cross-examination, she probably also say this, my Lord, when she was here for cross-examination, and Mr. Baz took her on it quite a bit, the petitioner stated that in those 14 polling stations, apart from the fact that that's where she votes from, in one of them, but those were also her strongholds. And that evidence was not challenged, my Lord. My Lord, why I mentioned that point is because the case overturned Okia Moses versus EC and Aliko Habad of 2021 turned on that point. But I'll refer to it, my Lord, at page 954. It turned on that point. Okay, the appellant in that case said, these areas which have been excluded from voting are my strongholds. It was not challenged at the Court of Appeal, my Lord. The case turned on that point. At page 954 of our bundle of authorities. Well, that's now volume 3, my Lord. Atan Okia Moses versus Aliko Habad. 954, yes, it begins at 9:33, but the holding is at 9:54. In fact, my Lord, when she was here, Mr. Baba said, hey, those were strongholds, okay, have the votes. Have them. But what? She actually gave them the vote, so The fact that they were not, they were phone calls was not. Now, my Lord, let me also give this test, because it might be confused. How do we get substantial effect? Because I saw the first respondent trying to bring another formula when the court supplied us one. How do you get substantial effect? My Lord, you do not use the number of people registered in the whole constituency. Why, my Lord? For example, in this matter, the results of 183 polling stations are ascertained and unknown, and there is no power. So if you want to get whether those people who did not vote had substantial effect, you don't use that number vis-a-vis the total number of voters in the constituency. We are not concerned with people whose electoral choice we know. How do you get substantial effect? You get it by comparing the margin between the winner and the runner-up, who is the petitioner in this case, vis-a-vis the number of those people whose electoral choice we do not know. Therefore, my Lord, in this matter, we are comparing 16,640 vis-a-vis 8,881. That vis-a-vis 8,881, which is the margin, yes, between the first respondent and the petitioner. My Lord, I am not getting that from my head, but from the decisions of the Court of Appeal, two of them. I'll take you back a little bit. The decision of EC versus Moscow, 2021. That's volume 2. That's volume 2, my Lord, at page 702. Where is volume? Page 702. That is where what I'm saying is. EC versus Moscow. Page 702.
What does that assume?
Just refresh, my Lord. Maybe, my Lord, as I look for that exact holding, I didn't appear to have highlighted it. Let me begin with the Acheng Saro Pendi at page 680. Page 680. In how we get the substantiality effect. Page 680. Acheng Saro Pendi and another versus. When my Lord starts at just a minute. Starts at 664. But the holding about this issue, my Lord, is at page 608. I have highlighted it. My Lord, the point is this. If you look at what we highlighted, what I'm saying is, when you are getting substantiality, you do not take into account the number of registered voters in the whole constituency.
Yes, but
The court said this, my lord. The land judge should have considered the total number of voters in those 15 polling stations. Here the issue was about 15. In those 15 polling stations, which was 7,000, that number, as compared to the winning margin of 7,600 without the same polling stations. And on page 680, we have highlighted that small part there. It's page 680. So that's how we get substantiality. My lord, back to Mosupo. Back to Moscow at page 702. 702. Back to Moscow at 702, my lord. It's paragraph, I think, 445. The one that has 445 at the left-hand side. It's not highlighted, but it says the court was trying to find out, my lord, what the number of the registered vote, what the number of those who had not been counted was, in order that they could compare with the margin. Now, my lord, let me underscore what I'm saying. Okay. If they can be looking for it. Now, my lord, let me underscore something as I get away from that point. And it's critical. I know that's why I'm going around and about it a number of times. The first respondent theory is that if you want to know whether the election was affected substantially, you look at the small number of 16,440 vis-a-vis the number of registered voters in the constituency. I am saying that is a wrong test. And I've given you the reason, my lord. You do not, in that test, take into account the number of people whose electoral choice has been ascertained. In this matter, my lord, the electoral choice that was not ascertained was only to do with 14 polling stations, whose total number of registered voters is 16,640. When we are looking for substantiality, it is that number, because it is those that we do not know how they voted, vis-a-vis the margin. If we find that those whose electoral choice we do not know is greater than the margin, then the election is put in doubt. Why? Because we do not know who would have voted what, at which polling station, what voter turnout. The mere fact that is greater, therefore, has the capacity to change the result of the election. Not change it for the winner to lose, not change it for the loser to win, but as to put the election in doubt. That had to be underscored very critically. Now let me take you, your lordship, how the courts have applied this test standard. The Court of Appeal, how it has applied it, what exactly I am saying. I'll begin with Apollo County. Yes, I'll begin, my lord, with Apollo County. In volume 2, my lord, the holding that I want is at page 573. 573. What was the problem in that case, my lord? The problem was that results from 9 polling stations were not included in the final tally. Results from 9 polling stations were not included in the final tally. I wrote I was telling that is at page 573 of the second volume. We have already referred to continuity, but we can just go back now for this point. 573. And we have highlighted the lordship. There results from 9 polling stations with over 5,000 voters had not been included in the final tally. The margin from the decade results was as low as 326 votes. Their lordships had this to say at all. In our view, in view of our finding above that the 9 polling stations had not been included, we do agree with the land trial judge that the outcome of the results of the whole Chadondo East constituency was left in doubt. The non-compliance therefore affected the outcome in a substantial manner, and the trial judge was justified in annulling the election on that ground. See, my lord, their lordships are not touching voters whose electoral choice is no. No. Only the 5,000 vis-a-vis the winning margin. And because the number of 5,000 was far greater than the winning margin, the lordships held that the election was affected substantially. I'll go to the next one, where this was applied as well. Wakaima Msoke Wakaima Msoke Nsereko, my lord, the case begins at 831, but the holding is at 870. I think we are in the second volume, page 831, but the holding is at 870. I think it's something that matters. And he lost this very point. Yes, but my lord, the holding is at 870. 870 is where the holding is. I'm just reminding Mr. Louis that he lost this point in that case. There are your lordships at page 870. They said, we agree with the trial judge that the total number of 17,239 registered voters in the 24 affected polling stations whose results were cancelled affected the outcome of the result in a substantial manner. Again, only those whose electoral choice was not considered, not the total number of voters. Permit me, my lord, again to take you to Betty Wamzanira Mkwasya. Permit me to take you back to Betty Wamzanira Mkwasya at page 755. The authority begins at Betty Wamzanira Mkwasya versus Winfred Komhanji. The authority begins at 744, but the actual holding is at 755. There, my lord says the decision applies to this case after quoting content Apollo, which I have just referred to. They said the decision applies to this case. The returning officer neglected to tally a substantial number of votes totaling 5,413, and he disregarded the same in his declaration of the elected candidate. Certainly went to the route of the electoral exercise. It amounted to disenfranchisement of the voters. Votes were not considered, the declaration of the winner. Then down there it says, consequently, the disenfranchisement of those voters substantially affected the outcome of the election, since the results declared contained in the return form indicated a much lower margin of 4,000. Then Muhindo Rehema, my lord. Muhindo Rehema versus Winfred Kiza, 90. Yeah, in volume 3, I think, my lord. Page, the first authority on page 3. Volume 3, yes. The holding is at page 890, my lord. There, my lord, 13,426 had not been considered. That first paragraph on top, my lord. And the lordship said that was significant to affect the result of the election in a substantial manner. Now, let me also say some of these legal points, my lord. The first one, when we are determining substantiality, my lord, the number of polling stations that the winning candidate has won vis-a-vis those of the losing candidate is irrelevant. As you saw, my lord, from the theory of the first respondent, he attempted to tell us that, look, I have won in so many. I would have won in those others. Before I get to that, the number of polling stations that you have won is irrelevant. My lord, I take you back to Mbaju Jackson at page 501. This is the second volume. Mbaju Jackson versus Tembo Gideon Mujungu, page 501 of volume 2 of our bundle of authorities. The actual holding is at 501. That case is the first one of volume 2. My lord, paragraph 92. The lordships in the Court of Appeal say it is true that neither the applicant nor the respondent number 2 won at any of the disputed polling stations. Just like here, we don't know who won. However, this cannot lead to the conclusion that such malpractices did not affect the result in a substantial manner. The election is won by the total number of votes cast and not by the number of polling stations at which the candidate wins. So that issue should be out of the way. It should not disturb your analysis, my lord. Secondly, my lord, the other point I wanted to emphasize on this issue as I walk away from it, it is irrelevant. It is theorization for the first respondent to say that because I won in the majority of the polling stations, I would have won even in those polling stations. And therefore, because he's saying that to say, my lord, that therefore the election was not or could not have been affected substantially. That theorization, my lord, when he came here in his answer and explanation and began talking about trajectories, patterns, and those kinds of things, my lord, I'm saying that is without legal basis. For you to say, my lord, that because I won there, I could have won there, that guesswork, as I called it, my lord, as a reason for saying that the election could not be affected substantially is without legal basis. Adding the number of votes and subdividing, as Mr. Mbabas took my client through, is without legal basis. It's guesswork. And my lord, of course, it is not lawful that courts will not act on guesswork. They act on real evidence. For that, my lord, I've given you the decision of Okale versus R in our third volume, I think. Yes, our third volume. Okale versus R. The page where the holding is 898. Okale versus R. It starts at 896, but the holding is at 898. There, my lord, the court was simply saying that courts do not act on fanciful theories. They act on real evidence. The reason, my lord, from the reading of the answer to the petition, the reading of the affidavit, my lord, if you followed the cross-examination of Mr. Mbabazi, the theory was simple from the first respondent. in the second, third group.
Melon just forgot to follow. We don't have 898, the one being quoted.
You have
Our copy has 891. From there it goes to 916.
that's it. Basically, just change it. It is there. The case is there. That one. Wait, right now. That case. I think the pages were misfired. We always we have both the violence. 898. My Lord, the point I was making before I was helping Mr. Sabganda is this: that this theory that the first respondent put in his answer and pursued in cross-examination, okay, was tending to show, the theory was to show that because of the patterns that he referred to, trajectories, guesswork, okay, he was saying that I would have won in those polling stations. But that's not where he stops, my Lord. He's saying because of that he won in majority, I would have won in the 14, therefore the election would not be affected substantially. That's where he leads to. And my point, my Lord, that I'm making with this decision is that that theorization basis and cannot be a reason for saying that the election would not be affected in a substantial manner. Let me also make this third point, my Lord, again as I walk away from this issue. What is at stake, my Lord, if we first put the rights respondent? Let's also think about the 16,640 voters who were disenfranchised. These people went to vote. We don't know how many went. We don't know how many turned up. But we know that people turned up to vote at these polling stations. But their results are nowhere to be seen, my Lord. They are not in the tally sheet. They were disenfranchised. My Lord, can we say, therefore, that their votes don't count, that their votes carry less weight, that their votes are irrelevant? My Lord, their lordships in the court of appeal have said no. Please don't treat them like that. This is the case of Mbagadi Frederick Nkai versus Dr. Frank Nyakuso. My Lord, that is at page 901, but the holding is at page 926. This is volume 3. The actual holding, my Lord, is on 926. Yes, but the authority starts at 901. My Lord, they are saying, please also look at the 16. Don't only look at the petitioner and the respondent who wants to be in parliament. There's something else at stake. It is the 16,640 voters whose electoral choice was not taken care of. And my Lord, this enfranchisement of these voters happened far from Mr. Muyizi's cross-examination of they voted so they were not disenfranchised. No. Disenfranchisement does not only mean being stopped from voting. It goes all the way. When I vote and my vote is not counted or not tallied or given less weight, I am disenfranchised in my vote. That is Apollo Kantinti. I will go back that decision. I don't want to take it back and forth. But what I'm saying is in that decision, that disenfranchisement also goes as far as that. When you go to that decision, you will see the various highlighted parts. Now, my Lord, disenfranchisement is fatal. Disenfranchisement of a number as great as this, nearly double than the margin, nearly double the margin between the first respondent and the petitioner, is fatal. The election cannot be upheld, my Lord.
I refer to the earlier.
Kantinti, my lord, is one of them. The other one I have is Atan Pokia. I think I also refer to it. My lord, continue to have is that effect. My lord, we have highlighted that particular part. I don't have to go back. You cannot give the 16,640 any less rate. Now, my lord, with that, on this point, I invite you to find an hold first that there was non-compliance with the provisions of the Parliamentary Elections Act relating to elections, and that non-compliance, my lord, affected the result of the election in the substantial. I now, my lord, I don't know if, yeah, I go to the next issue. The next issue is whether there was an illegal practice or any other offense under the DEA committed by the first respondent in connection with the election, personally or with his knowledge and consent. My lord, under this ground for setting aside the election, we pleaded for illegal practices or offenses. I'll begin with bribery. Bribery, your lordship, is prohibited under section 87, subsection 1 of the PEA. And my lord, from a long line of cases up to the apex court, they have interpreted that section again and again and crystallized 3 key ingredients of that illegal practice. For me to succeed on bribery, my lord, I should show you 3 things. Number 1, that a gift was given to a voter. 2, that the gift was given by the candidate or his agent. 3, that the gift was given to induce the person to vote for a candidate. Once I prove that, my lord, I have proved the illegal practice of bribery. My lord, that is stated, what I've just said is stated in the case of Gaddafi Nassour versus Sekabila Dennis, quoting the decision of Kizza Besigye versus Museveni. Those ingredients that I have proof, my lord, the cases are in 3rd volume. It starts at 963, but the actual holding is at 987. The actual holding is at 987, but the authority starts at 963. My lord, I'll go through the evidence of each incident of bribery. And I'll begin with that of Maumbe Jojo. I'll go through one by one, my lord, evaluate the evidence, and then make a general comment on the law. I'll not speak about the law in each incident. I'll speak about the law generally. But I have first take you through the evidence, my lord, for each incident. Now, I'll begin with Maumbe Jojo. This gentleman, on the 9th of April 2025, saw an affidavit for us, a petition. My lord, I think in the examination you were able to note the numbers, the pages where that affidavit is. But for abundance of caution, my lord, is at page 1276 to 1278. In that evidence, my lord, this gentleman stated that he is a registered voter at Clinton Junior School KI2M polling station. My lord, we gave that voter's roll as part of our evidence. On election day, he says that he met a man called Ben Kalakusa at Omar's place near a shrine under a jackfruit tree near a place called Zion Park. That place, my lord, is found in Chiganda zone in Kawempe North constituency, not very far away from where the polling station is. He said that when he got there, he phoned Ben Mukasa, giving money to several people, and he gave him 5,000 shillings and asked him to vote for the first respondent. My Lord, this witness came to the stand and was extensively cross-examined his affidavit, and he remained firm that he was given 5,000 shillings by Ben Mukasa. Ben Mukasa also gave an affidavit. I said, my Lord, I refer to it without prejudice. He gave an affidavit where in paragraphs, my Lord, if you could note them, 6, 7, 8, 9, 14, and 15, he made repetitive bare denials of having given this witness a bribe. He simply says, I did not see. Bare denials, my Lord. He actually says to his face that I know these allegations are not correct because Maube has said in the second affidavit that they are not correct. Of course, thankfully, my Lord, that second affidavit is now out of date. For Chamber Nathan Mwangs, the second incident, again, the registered voter at Clinton Junior School, AI to M, we have given the voters roll, my Lord. He says, that day of the election, he went to this parking lot and found Nachove and Ben Mukasa. Nachove gave him 10,000 shillings. Again, my Lord, the witness was cross-examined extensively, and rather than impeach, what was taken from that cross-examination, what I noted, is rather than impeach the fact that Nachove gave 10,000 shillings to Chamber, my learned friend who was cross-examining was only asking what the witness had done for Nachove to receive the 10,000 shillings. So the fact of receipt of the 10,000 shillings was not impeached. What the lawyer was trying to get around about was what was it for? And all this was towards the day of the election. The witness said, I have no relationship with Nachove or Ben Mukasa, and there could never have been any other reason to give me the 10,000 apart from voting for the first respondent. Nachove saw an affidavit, my Lord. I'm referring it without prejudice. Nachove made only bare denials. Okay, I did not give that man money. But what is striking are two things from her affidavit, my Lord. If when you retire, you look at it. Two things lavishly strike from that affidavit. The first one is that Nachove does not deny in her affidavit knowing Chamber Nathan Mwangs. She doesn't say so in her affidavit. She only says, and I quote, that she does not know Chamber Nathan Mwangs pertaining to the issues of Kawempe North by-election. So she doesn't say I don't know him. She says I don't know him with regard to issues of Kawempe North by-election. Something else striking from her affidavit, Nachove. She does not deny being an agent, the first responder. Others try to deny generally, but this one doesn't deny at all. My Lord, I need to highlight in these two instances, if I go to the next one, I need to highlight the evidence they gave in court here during the examination when they stated that they were approached by Ben Mukasa and told and coerced and intimidated and whatever they said Ben Mukasa and whoever he did it with did to them. I must note that for these two incidents, that evidence that they gave here in the examination is critical, my Lord. Okay, how they were approached by Ben Mukasa again, that this evidence will disappear. That is a key highlight of those two incidents. On the third one, my Lord, at Pentecostal Church Polling Center, Wanjala Solomon came to the stand. Wanjala Solomon came to the stand and said, I saw Ben Mukasa give money to voters who included Dr. Wamukubira. When he was at the stand, my Lord, he demonstrated the distance between him and the veranda where Ben Mukasa was giving the money for. And as you could see, my Lord, it was a very short distance. Wanjala could see what was going on. Something is striking from the affidavit of Ben Mukasa with regard to this particular incident, my Lord. In that affidavit, from paragraph 1 to the end, Ben Mukasa does not deny that he was at that polling station. Nowhere does he say, I was not there. He only says, I did not leave because the presiding officer asked me to leave. Kind of literally saying, I left on my own. But he doesn't say, I was not there. Again, he says, he doesn't know I wasn't there. He says, I am not aware of any complaint filed against me at this police station by Wanjala Solomon. That's what he says in his affidavit, but he does not say that Wanjala Solomon, you are lying, I was not at that police station. He doesn't say that in his affidavit. Now, with regard, my lord, to those three incidents, there's something I want to highlight. Maumbe, Chamber, and Wanjala. Let me highlight this, my lord, with regard to those three incidents. All these three incidents, my lord, took place in Chiganda Zone, LC1. The polling station of Clinton Junior, KI2M, and Pentecostal Church polling center are both within Chiganda Zone, LC1. So Ben Mukasantale was operating from Chiganda Zone. And he does not say, by the way, in his affidavit, or even in Nacho, none of them says they were not in Chiganda Zone on election day. None of them say so. In fact, from the evidence of Chamber Nathan Mount my road, this gentleman we're talking about, Ben Mukasantale, is a resident of this Chiganda Zone. He's a leader of that zone. And he confirms that, my road, in his own affidavit. So I thought I could highlight that bit, that this is all in Chiganda Zone. Now, at Sekati, Navakoza Rita, bribery by Navakoza Rita in Sekati Zone, one of the photos and everything. My lord, a witness, Navukenya Margaret, came and he said,
This first one was
the first one was Maumbe.
by Kasantari.
Yes, all those three incidents were bribery by Mukasantale. There were three incidents.
Shift to Navajo.
To Navakoza, yes, ma'am. Mukasantale, my lord, and Nachobe in the first three, because Chamber was bribed by Nachobe. So the first three instances is Ben Mukasa and Nachobe. This one is Rita, Navakoza. And I'll say this very briefly, my lord. Our witness came here, Navukenya Margaret, and told us Navakoza Rita went to a registered voter called Chibuka Mary Diana and gave her 1, 2, 3, 4, 5 items. 2, she stated that this was during the election campaign. This was during the campaign for the by-election. When Rita came here, my lord, she did not deny. She did not deny that she was at the residence of Mary Chibuka Diana. She did not deny that she gave out the items. All she tried to do was to give a different version now of what she was doing, okay, during this campaign period. But at least she doesn't deny that during this campaign she was at the residence of Mary Chibuka Diana and that she gave out these items. That is paragraph 12 of her affidavit in support of the first respondent's answer to the petition. When we cross-examined her, my lord, we were able to show that on this particular incident, when she went to Mary Chibuka Diana, she was wearing the party symbols of the political party of the first respondent. The photograph that he attached to try and give a different version of what she was doing, as we saw, my lord, towards the end of cross-examination, collapsed like a pack of cards. He started by saying, I took them with this phone. As it later transpired, the phones were different. Some she had gotten from Facebook. It later transpired, she didn't take them to the printer. The lawyer took them to the printer, blah, blah, blah. So that chain was completely destroyed. And so was her version of events as to what happened during the campaign for the by-election of our nation. My lord, also note, in all the incidents now, all of them, these people who are alleged to have committed the bribery, all of them are NUP leaders, National Unity Platform leaders. All of them. And they say so in their affidavits, my lord. They are leaders and they are sponsored by the National Unity Platform. That is Rita, Nachobe, and Ben Itali Mokasa. My lord, which now brings me to the affidavit of the Secretary General of the NUP, David Lewis. There, my lord. Yes, my lord. I was evaluating evidence, then I go to the law. which brings the affidavit of Davis Lubongoya, where he says in paragraph 5, 6, 7, 11, and 12, he says in all of those paragraphs, he indicates, one, that the NUP sponsored the first respondent. That's not in doubt. The first respondent agrees with it. Two, that party functionaries were active in the campaign and on the day of the election. He states, as you will see, my lord, that officials of the party were there. He actually says himself, I was there supervising the polling stations. Actually said, I am the one who took care of the welfare of the agents of the first respondent. Now, let me go to the law, my lord, touching on all of those points that I've been talking about. Now the law. First of all, my lord, who is a registered voter? Because I have to prove, remember the first thing, great, my lord, I need to prove that the person who was bribed is a registered voter. Who is a registered voter? Section 1 of the Parliamentary Elections Act defines who a registered voter is. How? As a person who appears on the National Voters Register. Once you appear there, whether you have a national ID, whether you have a voter slip, whether you have what, all of those things don't matter. Their lordships in the Court of Appeal have twice told us that a registered voter is the one who appears in the National Voters Register. My lord, for that position, I have the case of Gaddafi Nassau, which you have referred to earlier. My lord, you will revert to it at some point. But the new one that I want to introduce, my lord, is the case of Simon Muyanga Butaya. It is in our third volume, and the specific holding I want is at page 1016. 1016. Simon Muyanga Butaya. Am I pronouncing the name wrong? Am I pronouncing the name wrong?
My lord, I'm Alex.
Simon Muyanga Butaya. Muyanja, I think. He has corrected me, my lord. The point I wanted to bring with that decision, your lordship, at that paragraph, at that page where I've taken you, is that for you to prove that you're a voter, you don't have to have a national ID. No. You don't have to have a voter slip, as I saw my colleagues representing my witnesses here. All that is irrelevant. Once you appear on the NPR, that is it. You're a voter. And my lord, we have demonstrated that all people who were bribed in all these incidents were registered voters. Mawumbe is, Chamber is, Wampuira is, Chibuka Mary Diana is. These were the 4 people who were bribed. We have demonstrated that all of them are registered voters. Second, my lord, what was the purpose of the bribe? That's the third ingredient I have to prove if I go back to the second one. My lord, who gives money to a registered voter on the day of the election for anything else other than to induce them to vote for the first respondent? These people came here. They said, we don't have relationships with these people. We don't owe them money. They are not our relatives. So there is no other reason why they would have given us money apart from inducing us to vote for the first respondent. My lord, for that, I don't want to waste too much of your time. I refer to the decision of Namboze at page 1064. You will see the decision there. It starts at 2023, but the actual holding is at 1064 and 1065. And I'll highlight it. And for now, on the part, my lord, of what could have been the purpose? What is the reason why you're giving away these things? For now, my lord, we submit that she gave out these items to a registered voter when the election was imminent. It was during campaign. Giving a gift to a voter during campaign is prohibited. These gifts were given during the official campaign period, which admitted on the stand and when the election was imminent. In Namboze, Bakaruba, the Supreme Court said, no, actually, no, my lord, that is Bada, Freddy Bada versus Professor Muyanda Mutebi. Professor Muyanda Mutebi Same situation, the election was 1 week away. Professor Miyanda Mutebi gave a cow. Their Lordships, the Supreme Court said that gift would not have been interpreted in any other way apart from a gift to a voter to induce them to vote at the election. Now, let me go to the second ingredient now. Now, my lord, this illegal practice we are talking about, you have not seen me anywhere mention the first respondent himself. Okay? What now behooves me to prove and show to you, my lord, is that this illegal practice was committed with his knowledge and consent or approval. I have submitted, my lord, that all these people involved in this instance of bribery are NUP political leaders. NUP political leaders who, as I have said from the affidavit of Ruongoya, actively participated in the campaign and election of the first respondent. They are all NUP political leaders who actively participated in the campaign and election of the first respondent. And Mr. Ruongoya puts them in the field for that purpose. And the first respondent, my lord, says he is sponsored by his political party. That's fine. Now, my lord, my argument is, this first respondent here, Mr. NALUKOOLA, cannot on the one hand take benefit of the good activities of what his party did, and on the other run away from the illegal practices of what his party officials did. He cannot approbate and reprobate. I'll give you an example, my lord. In the affidavit of David Lewis, what does he say? He says, on election day, I moved around, supervising all polling stations and taking care of the welfare of the first respondents' agents. My lord, Ruongoya was not the candidate. He is the Secretary General of the National Unity Platform. And he's saying that's what he did. My point is, the first respondent cannot take benefit of that. Okay? That's okay for my party to do. They took care of the welfare of my people. When it comes to bribery, you say, no, those are not my things. Those are not, I don't know those people. He cannot approbate and reprobate. My lord, that's not a noble principle, but if it pleases you, I could refer you to the decision of the Supreme Court that has that principle at page Codro 1 of our bundle. Codro 1. The case name is Bison Okum and others versus UGCL and others. That's where the principle of approbating and reprobating comes. Let me also make this point, my lord, about these officials of the National Unity Platform. These are not non-influential political functionaries or leaders. No, these are councillors from their areas of operation, from their areas of the constituency. These are councillors who clearly were deployed by the party in the areas which they represent in the national leadership, where they knew the terrain very well, so they could carry out the practice of bribing people with utmost sophistication. These are not any lousy NUP people. No, these are leaders. They are not your street boys. No. These are leaders, these are national leaders, all of whom are of the National Unity Platform. What has the court said about people like that and bribery? What has the court said? My lord, I refer to the decision of Yamukama James. Yamukama James versus Keja William. That decision, my lord, is in this third one. Is in our third day band of authorities. It starts at page 1121, but the actual holding is at page 1163, my lord.
We shall take a short break. We shall resume at 12:15.
I'm obliged, my lord.
Kkooti evuddemu mpaka eddakiika 2 oli ku Shalom Television Uganda Ssebanyamu mpeereza ekyokola kyakabi kyokola kya ttendo Dr. Nzandiza nkuweereza ngenda kujja ku katono tukomewo ku saa 6 n'eddakiika 2 nagambye musango guno kukunyumira olina okugugoberera si buli kimu kyeyogera musango guno kijja kukunyumira si byonna byeboogera nti bigenda kukunyumira kitegeera